That's not asset protection. That's creating a paper trail of potentially fraudulent filings.
This is the Asset Protection Show. Expert strategies by attorney John Skabelund.
Welcome to the Asset Protection Show. I'm attorney John Skabelund and your host. Today, I want to talk about a loophole a lot of people are buzzing about right now. Using a Montana LLC to avoid sales tax and registration fees on business vehicles, high-end cars, RVs, and toys. I interviewed tax expert Scott Hodge in episode 25, who discussed the fine line between tax avoidance and tax evasion. That led to a brief discussion on Montana LLCs. He shared his tax perspective. Today, I'm going to share my legal perspective. Over the last year, I've had a noticeable uptick in calls from clients asking some form of this question. John, I heard I can set up a Montana LLC, title my business vehicles, exotic car or motorhome there, and skip the sales tax. Can you help me with that? Let's quickly explain what they're talking about. Montana has no general sales tax and allows non-residents to form LLCs without living there, just like other states. If you create a Montana LLC and title the vehicle to that LLC, you can often register it in Montana with no Montana sales tax and relatively low registration costs. That's why you see Montana LLC packages marketed as promising a fast, cheap way to buy a Ferrari, a big RV, or an off-road toy tax-free. The sales pitch implies if the title says Montana, you're good. But that's not how most states see it. Your home state treats you and your vehicle as a resident and taxable. Before we even talk about enforcement, we need to clear up a popular myth, the 6 months and a day rule. You'll often hear people say, I'm only in that state 5 months a year, so they can't tax me. Or, as long as I keep it under 6 months, I'm safe. That's dangerously oversimplified. Many states use some version of a 183-day rule as part of a statutory residency test. If you maintain a permanent place of abode in the state and you spend 183 days or more there in a year, if you meet both, they can tax you as a resident, even if you claim domicile somewhere else. But 3 important caveats apply. First, not all states use the exact same test. Second, the 183-day threshold is usually a floor for statutory residency, not a safe harbor. And third, residency can still attach through a domicile, even with fewer days. Every state with an income tax has a separate concept called domicile. If a state concludes your true home base is there, your primary home, family, business interest, voter registration, driver's license, that state can treat you as a resident even if you're physically present for far less than 183 days. So you can spend well under 6 months in a state and still be a resident if your life is clearly centered there. On top of that, a minority of jurisdictions have statutory residency rules that don't fit the simple 6 months and a day story. Some states use more subjective tests like whether your presence is temporary or transitory, meaning that they can find residency based on your facts and circumstances, even below 183 days. 2 jurisdictions, District of Columbia and Virginia, can assert statutory residency based solely on maintaining a place of abode for more than 183 days with no minimum physical presence requirement. The takeaway is simple. You cannot rely on a day count folklore. States look at where you actually live your life, not just whether you stayed under the 183 days. So how does this tie back to the car? Most state vehicle and tax rules follow the same basic idea. 1, you're expected to register and pay sales or use tax where the vehicle is based and primarily used, where it's garaged and driven, not just where the title happens to say. So if you live in Utah and your car is actually used in Salt Lake City, Utah expects you to title, register, and pay tax in Utah, even if the paper owner is a Montana LLC. To be even clearer, if you live in California, drive that car on California roads, California expects California registration and California tax regardless of Montana plates. There are narrow, legitimate, non-resident registration situations, such as snowbirds, people with multiple homes, vehicles truly based in a different state. But using a Montana LLC to disguise where the vehicle actually is used or not is not one of those. Let me be clear. I refuse to help clients use a Montana LLC for the primary purpose of evading their home state's sales and registration taxes. Here's why. First, states are actively cracking down and are no longer ignoring this. A number of states are developing tougher enforcement strategies against what's commonly called the Montana loophole, and they're using data analytics and interagency cooperation to identify vehicles that are registered to Montana LLCs but obviously used somewhere else. Tennessee, for example, explicitly warns residents about schemes involving out-of-state LLCs like those in Montana or Alaska, and makes it clear that if the vehicle is brought for use in Tennessee, Tennessee taxes still apply no matter where the LLC is registered. Further, California tax authorities and DMV have announced joint enforcement targeting dealers and buyers who use Montana LLCs to avoid California tax, with the possibility of back tax assessments and penalties up to 50% of the unpaid tax. We've got Whistling Diesel in Tennessee as an example of someone who got caught using the Montana loophole. But California recently also charged 14 supercar owners in the Bay Area for essentially the same pattern, using a Montana LLC to register their vehicle and having the vehicles used in California. At least 5 states, California, Georgia, Utah, Indiana, and Missouri, are moving from a wink and nod to actual plate readers. Dealer audits and criminal charges focus specifically on the Montana loophole. Recent guidance notes that states can and will impose back sales or use taxes, penalties, interest, fines, and even criminal charges in serious cases. Forming an LLC in Montana is legal. Registering a vehicle in Montana is legal. But when your intent is to avoid taxes in the state where the vehicle actually is used and driven, you misrepresent to your home state that you've moved out of clever planning and into potential tax evasion. Some state guidance is quite blunt. Deliberately registering your car in another state to dodge sales or use tax when you primarily use it in your home state can be prosecuted as a misdemeanor or even a felony, depending on the amount. That's not asset protection. That's creating a paper trail of potentially fraudulent filings. You really need to ask yourself, what do you really save? Maybe 5 to 10% of the purchase price in tax, but at what risk? You're risking back taxes plus interest, penalties that can be 25 to 50% of the tax due, sometimes more, possible criminal exposure if the state decides to make an example of you, and vehicle impoundment or being forced to re-register and pay everything at once. My law firm and I educate our clients that good, clean living is expected and a necessary part of asset protection. Just because we protected a client's assets does not mean a client can drive 150 miles an hour down the freeway believing they are protected. Asset protection planning does not protect a client from criminal liability. On occasion, a client states the reason they desire to create an offshore trust is to avoid U.S. federal income taxes. We will refuse to help such a client and will decline representation. I believe sales tax avoidance falls into the same category. So what's the right answer? Number 1, stay in tax compliance. Almost every state's basic rule is register and pay tax where the vehicle is based and primarily used. If you live in Tennessee and you use your car in Nashville, you should title and register in Tennessee and pay the applicable state and city sales or use tax at registration. If you live in California and you're driving that car every day on California roads, California expects you to register it there and pay its tax. There are situations, again, where Montana registration can legitimately make sense. For example, full-time RVers with no fixed home state, vehicles genuinely based on Montana for a Montana business, or vehicles used primarily in other states and only temporarily passing through. But those are narrow fact-specific situations, not I live in Scottsdale, but my Lamborghini is owned by my Montana LLC. If you're my client, I'm going to push you to register where you actually use the vehicle. Treat sales and use tax as part of cost of ownership. Avoid cute schemes that look good on social media, but play badly under audit. Now, I know some of you are listening still are going to say, John, I hear you, but I'm willing to take that risk. If you're absolutely determined to go down this path, I'm going to give you one piece of advice, and this is not an endorsement of the strategy. But if you do the Montana loophole, do not run it through some random online Montana agent or LLC company. Work only with an experienced Montana law firm. And here's why. First, when you talk to a non-lawyer, service company, or agent, there is no attorney-client privilege. And if or when your home state investigates, that company can be subpoenaed and may hand over emails, contracts, and payment records. Second, a Montana law firm, by contrast, can provide legal advice, evaluate whether your facts legitimately fit within the law, and communications with them are generally protected by attorney-client privilege, subject, of course, to the usual limitations about ongoing criminal conduct. Again, my advice is don't use this as a tax evasion strategy. But if you're going to wade into a legally gray or risky area, at least don't do it with a discount website that will roll over when the state shows up. So let me wrap up with this. Asset protection is about building resilient, compliant structures, utilizing LLCs, trusts, entities, and insurance that actually stand up in court and under audit. It's not about pretending you live in Montana while your business vehicles sit in a garage in Washington. The real solution is simple, but not sexy. Register where you live and use the vehicle. Pay the tax you legally owe. Use legitimate tools like proper entity structures, insurance, and jurisdictional planning for real asset protection, not cheap tax schemes that can blow up later. If you've been pitched that a Montana LLC is a no-risk way to save tax on a vehicle, or you're wondering how to structure things the right way, you really need to meet with an experienced asset protection attorney, not an estate planning or business lawyer. I hope you've enjoyed learning more about the Montana loophole and why it's dangerous. Thanks for listening, and until next time, stay protected.
You've been listening to the Asset Protection Show, expert strategies by attorney John Skabelund. For more information, go to assetprotectionshow.com.
This content is legal information only and not legal advice. Viewing this content does not create an attorney-client relationship. Mr. Skabelund is admitted to practice law in Arizona, and he may be reached at ultimateassetprotection.com.